preview. Says we're live. Let's just go. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. And I think we're live, so we're just going to go. Welcome, everybody. I'm Leonard French, your favorite copyright attorney, and I've got a fun one for you today. Thank you first for putting up with me. I am sick, or at least recovering from being sick. My voice is a little bit hoarse, and, this is a bit of a low-effort stream, so I really appreciate you putting up with me and what we're doing here. Let me know if we are really live. Is sound... Yep, sound is going. Let's see. So I think we're going to be going... Yep, Justin says we're working fine. So let's just jump straight into it. I'd like to introduce a new Frivolous litigant. Now, I want to be kind to this person. We don't know their background, and you're going to see some things in here that are... a little bit, we should have compassion for this person. So I'm not going to be relentlessly making fun of them, but I do think these are some really interesting and maybe fun and entertaining complaints, and then we'll see how the judges shut them down. So let's introduce to you Samuel Darnell Yates, who has been filing for the past half a year or more in the Northern District of Ohio. There are 4 cases here. They're relatively short, and so it's not going to take too long to get through them. This first one is a lawsuit against the city of Barberton, Ohio, and let's just go through and see what he has to say here. This is a federal question jurisdiction case. That means it's a case that belongs in federal court because it's like copyright or some law that is federal. This says, as a short, plain statement of the claim, they illegally chained the doors. Now I have been left paralyzed on my left side, and I have been diagonalized with scoliosis of the spinal cord. I'm assuming he means diagnosed. And he seeks relief. I ask the courts respectively to, I think it's respectfully. Respectively is like when you name 2 things and it's like, I mean the first one and the second one. I ask the courts respectively to grant my request to be awarded the sum of $481 million US, for I was this state's first NFL player to go straight to the NFL from high school. And I had a band teacher that knew what talent was when he seen it. It wasn't about the color of my skin complexion, and now, unto the great tailbacks from this state, the state will possibly never see a Super Bowl. Now, I had 4 scholarship to college, and I had a beautiful and outstanding future looking at me. Okay, and that's it. That's the first one. However, there's an attachment here. Remember, he's asking for $481 million. There's an attachment here, a story. Let's tell the story here. It was the first day of school, my freshman year of high school, 1988-89, in the city of Barberton, Ohio, at Barberton High School. Walking up to the school, everything around me seemed as if this was about to be the beginning of a merit roll student's outstanding future towards manhood and maturity. Being approached by the mobbed crowd standing outside the school chanting and yelling at what I could not see anything silly to mustard, but the fact that the students did not want to be there on this sudden day of bravery and marksmanship. I think marksmanship is a bad word to use when you're talking about schools. I had several scholarships riding upon my academic sight manhood unto respects and outstanding manship, one for academics, one for band, one for football, and one for baseball and soccer. I was supposed to go up to Barra, Ohio to participate in the Summer Youth League's football camp at the Cleveland Browns practice stadium, for which I received a special invitation by the Browns starting tailback Kevin Mack, who came to Barberton Varsity Teen Youth Center Club to invite the ONE1, the team, had seen looking at his future from and inside the state of Ohio. Does anyone else feel like we're channeling Charlie Kelly here? My band teacher, Mr. Chavazio, had informed me at the beginning of the school year, coming from UL Light's band class, that he was about to submit my scholarship applications unto schools like Purdue, Pitt, and Penn State, for I was an outstanding and talented musical student when it came unto being inside of a classroom. I was looking also unto becoming the first youth in NFL history unto being drafted straight out of high school. But since the rules were that a child had to first enter college for at least 1 year, but looking at 2 first, the commission was going to argue the ruling of letting NFL players come straight from high school if the teens seen something in the players that others did not. Quote, "The chains had been placed on the doors, and we had to hurry up to first period without being late or tardy. Doors serve as a variety of needs and purposes in schools. Exterior doors provide building security and protection from the elements. Interior doors control the movement of people among school spaces, help control noise and airflow, and act as flame and smoking barriers during a fire. In a lockdown, they serve as safety barriers," page 2. From a security perspective, the most important function of a door is to control entry, page 4. From the standpoint of fire safety, however, a door's exit function is the ruling factor, one that is highly regulated by building and fire codes, true, that classify doors as part of a building's means of egress. When I asked the substitute teacher to excuse myself for a second and go use the restroom, when I opened the door, it was completely black in the hallways, and it seemed as if there was no oxygen in the hallways or circulating through the building. So I immediately closed the door, for wheat I had seen, I'm assuming he means what, for what I had seen as warmth, happiness, and comfort had now become a living nightmare amongst honor and survival. I went straight into the window and opened it up so that the classroom could get some fresh airflow circulating back unto the hot, dense, and moist classroom that had now seemed as if it was lifeless and motionless. So I went to the window and sat out on the window ledge, and the students started yelling at me to jump. When I jumped, I could see the windows opening up and the other students feeling the same way as I did about life, dreams, and the pursuits of liberation. When I landed on my feet, I looked at the clamping and cheering, and then all of a sudden I just fell backwards into the window hole of the high school that outlined its landscaping. For a minute I just sat there and looked at everything around me. Then I attempted to get out of the hole, for which I got up, my back just snapped. Now I'm left with scoliosis of the spinal cord behind this. And I had 2 broken collarbones, which now prevents me from going back to school to play football, or being able to sit up straight for long enough to read my trumpet music book. I mean, if the guy really got hurt, I really feel sad for him. In occupied buildings, egress doors can prevent entry, but they can never prevent exit. International Building Codes 2006 edition, International Fire Codes 2006 edition. Egress doors shall be readily openable from the egress side without the use of a key or special knowledge or effort. Doors shall be arranged to open readily from the egress side whenever the building is occupied. Exterior doors. There are many stories about school staff illegally chaining exit doors shut to keep out strangers and contraband. As dangerous as this practice is, one can empathize with school administrators trying to balance dance competing concerns. I'm assuming he means like balance and dance around competing concerns. Summary. Any means used to prevent exiting through a doors on the egress path when the school is occupied is unsafe and strictly illegal. Resources, the U.S. Department of Education, Office of Safe and Drug-Free Schools, National Institution of Building Sciences. So what do you think the judge did with that? Now, remember, judges are supposed to take pro se complaints, unrepresented parties, and try to figure out what they're doing and see if there's anything there to really do anything with. So then, back to an actual judge writing here. Judge Sarah Leoy writes, pro se plaintiff Sam Darnell Yates brings this action against the city of Barberton, the Summit County Board of Education, and the fire department. Yates proceeds with this action in forma pauperis. That motion is granted, but the case is dismissed. Yates states that the basis for the court's subject matter jurisdiction is 28 U.S.C. 1331, which identifies the federal statute, where he identifies the federal statute as issue as the National Fire Protection Association Life Safety Code. The claims in this case arise from events that occurred during Yates' freshman year at Barberton High School. Yates states that he was a talented musical student and football player with a promising NFL career ahead of him. According to his complaint, Yates opened a classroom window to let fresh air in and sat out on the window ledge. Students yelled at him to jump, so he did. He landed on his feet, but then fell backwards into the window hole of the high school that outlined its landscaping. When he attempted to get out of the hole, his back just snapped, leaving him with 2 broken collarbones and scoliosis of the spine. As a result, Yates could not play football or the trumpet, ending a promising future. Yates alleges violations of certain sections of the International Building Code. And asks for $481 million in relief. Pro se pleadings are held to less stringent standards than formal pleadings drafted by lawyers and must be liberally construed. That said, the court is not required to conjure unpleaded facts or construct claims on plaintiff's behalf. If the court determines at any time that the court lacks subject matter jurisdiction, it must dismiss the action. Federal courts are courts of limited jurisdiction and have a duty to consider their subject matter jurisdiction in regard to every case that may arise sua sponte, which means on its own. Generally speaking, the Constitution and Congress have given federal courts authority over a case only when the action raises a federal question or when diversity of citizenship exists between the parties. Absent diversity of citizenship, federal question jurisdiction is required. So the court is going to dismiss it based on a lack of federal question jurisdiction. The first type of federal jurisdiction relies upon the presence of a federal question. For example, we often see copyright claims. Copyright is a federal question. No state can adjudicate copyright. Federal question jurisdiction arises where a well-pled complaint establishes either that federal law creates the cause of action or that plaintiff's right to relief depends on resolution of a substantial question of federal law. In determining whether a claim arises under federal law, the court looks to the well-pled allegations of the complaint. Although the well-pled complaint rule focuses on what a plaintiff alleges, it also allows the court to look past the words of a complaint and determine whether the allegations ultimately involve a federal question. Liberally construing this complaint, it appears Yates is alleging that defendants violated certain fire code rules and industry standards, and those violations resulted in his injuries. But there are no allegations from which this court may infer that those standards have been adopted by Congress or promulgated by any federal agency or department, such that they have the force of federal law. So the fire safety codes apparently don't have the force of federal law. And the parentheses here, finding that this case quadrant EPP USA, finding that alleged failure to comply with the fire safety code NFPA 654 did not violate the OSHA code because the fire code has not been adopted by Congress. Many building, fire, and electric and other safety codes were originally developed as industry standards by non-governmental entities and then adopted into law. Such privately developed codes can be adopted into law directly or by reference, even with the benefit of a liberal construction. Yates has not alleged a federal question, and none is apparent to the court from the face of the complaint. Even if Yates did allege a violation of federal law, Yates' claim concerning the events that occurred 30 years ago would be dismissed by time barred by the 2-year statute of limitations. Thus, the court lacks subject matter jurisdiction. The court also lacks diversity jurisdiction, which is when if you sue between if you're in one state and you sue somebody in a different state and it's more than $75,000 of liability claimed in the complaint, then that's another way to get into federal court. The second type of federal jurisdiction is applicable to cases of sufficient value, but between citizens of different states. That's diversity of citizenship, like I just said. Excuse me. To establish diversity of citizenship, a plaintiff must show that he is a citizen of one state and all the defendants are citizens of another state, etc. There is no claim in the complaint over which the court may exercise subject matter jurisdiction. The court lacks authority over this matter. There are no allegations in the complaint which the court may infer the existence of diversity jurisdiction either. Accordingly, this action is dismissed according to Federal Rule of Civil Procedure 12. The complaint provides no basis for federal jurisdiction and the action may be dismissed as frivolous and so ordered. For the foregoing reasons, Yates' motion to proceed in forma pauperis is granted, but his case is dismissed, and the court certifies that they don't believe that an appeal could be taken in good faith. So ordered, the Honorable Sarah Leoy. Sorry if I'm butchering your last name, Judge Leoy. So then we have another one here.
Yeah, judges deal with all sorts of people.
Now he got before Judge Adams and Judge Burke in the Northern District of Ohio again. This time he's suing U.S. President Donald Trump. So let's scroll down here and see what he has to say. On 11/13/2018, looks like the amount here is $50 million. The defendant signed and delivered a note promising to pay plaintiff the sum of $50 million. So the defendant is Trump. With interest at a rate specified, which is apparently not specified. And the promissory note is apparently, $50 million. Let's see what this is about. The relief requested is that the defendant be ordered to DHL or FedEx delivery from United States Treasury Department a check to Samuel Darnell Yates, or he can come to Washington to pick it up for $50 million.
That's reasonable. You know, it's like, well, if you can't make it to the FedEx office, I'll come to you.
And what do you think the basis for this one is? Let's see what he attached. This was one of the attachments that was sent here, or attached to the complaint. And this is so she claims to be from Mrs. Melania Trump at an email address of mrs.melania.trump253.arrow.ocn.ne.jp. Because, you know, Melania Trump would use a Japan email address. And the reply to, of course, is a different address, a Gmail address, mrs.melaniatrump253@gmail. On behalf and authorized right of President Donald John Trump, I'm Mr. No space, Donald John Trump, and the content of bellow message is signed and approved by United Bank of America. Okay. I am Mrs. Melania Trump, but I thought you just said you were Mr. Donald John Trump. This to officially inform you that your overdue payment from the United States of America, total sum of $50 million is currently here in my office, White House, Washington, D.C., and the funds will be delivered to you as soon as you get back to this office and comply with the requirement as needed to transfer or deliver your total fund to you as well. Moreover, in respect of fact, the sum of $50 million United dollars, the dollars are united, by the way, was instructed to transfer on your favor through check draft, and I wish to let you know that every necessary things has been accessed by IMF, which I'm assuming would be the International Monetary Fund, on the economic recovery program done by United States Embassy in Government House, Gesundheit, of Mr. Trump's for victim who lost fund to con African artist, and you have nothing to be worried about. In case anybody thinks maybe there is something to be worried about, or maybe not, this is what scams look like. I'm pointing out the things that are reasons why you would know this was a scam. The email address, for example, especially 2 different email addresses, an official something purporting to be officially from the government, but using a Gmail address or using a Japanese email address, completely misspelled, completely understandable. But why do they do that? Because, intelligent people should be able to tell the difference. They don't want to reach intelligent people and get and waste their time. They want to reach people who can't tell the difference. To put it politely.
This poor man.
Yeah, and I feel bad. I really don't. I'm really not trying to make fun of him. It's entertaining and it's educational and it's entertaining. But I do want to be clear here. I am not making fun of this person. They have obviously. There's reasons to be compassionate with this person. So below is required information: home address, cell phone number, email address. We advise you to prohibit any other transaction you are having with an unknown source to avoid regret thereafter, and we urge you to comply fast with the managerial demands so that you can have your legit checkbook with immediate effect as instructed from White House, Washington, D.C. Thanks, and always be blessed. At least they're nice. And so what do you think happened with this one? Let's see what Judge John R. Adams has to say. Pro se plaintiff Samuel Darnell Yates filed this action against President Donald Trump. In the complaint, plaintiff alleges he received an email purporting to be from the First Lady, Melania Trump, promising him $50 million as compensation for being defrauded by an earlier email scam from Benin, Africa. He simply had to provide $250 in the form of an iTunes gift card. By the way, when the government contacts you, they're never going to ask you for an iTunes gift card. You are not going to get prosecuted by the IRS or the Social Security Administration or the Attorney General or something, and they're going to say, send us $250 in the form of an iTunes gift card. Trust me, those people make more money than that. They don't need to ask you for a $250 iTunes gift card. And the consideration was for a presidential immunity waiver certification. He received another email informing him that he would be required to pay a delivery fee. He seeks $50 million that he was promised. The application for informa pauperis is granted, and we know that those pleadings are, the pro se pleadings are liberally construed, and we're going to skip some of this. A pleading must contain a short, plain statement showing that a claim exists and the pleader is entitled to relief. The factual allegations in a pleading must be sufficient to raise the right to relief above the speculative level on the assumption that all the allegations in the complaint are true. The plaintiff is not required to include detailed factual allegations, but must provide more than an unadorned defendant unlawfully harmed me accusation. Awkward wording. A pleading that offers legal conclusions or a simple recitation of the elements of a complaint or cause of action will not meet this pleading standard. In reviewing the complaint, the court must construe the pleading in the light most favorable to the plaintiff. As an initial matter, plaintiff does not specify the legal claim or claims he intends to assert. The only possible claim the court can liberally construe from the pleading is one of breach of contract. To have a binding contract, however, the parties must agree to the terms as actually expressed through offer and acceptance and must have a meeting of the minds as to those terms. Although the email in this case contains the name of the First Lady and purports to be an authorization from the President, There is no indication that this is a legitimate offer by either of them. In fact, it appears to be another email scam by someone posing as the First Lady, hoping to lure plaintiff into sending money with the unsolicited promise of receiving a large money sum in return. Plaintiff failed to allege facts suggesting that he had an enforceable contract with the President or the First Lady. And same thing, it gets dismissed. So that's the second one. There's two more of these, by the way, and they're also worthy of our compassion. So this is before Judge Leoy again. Samuel Darnell Yates versus Patricia Ann Yates and Sandra Bennett Robinson. So I'm going to guess that this person is related to him in some way. Let's see what he has to say. This is where we should really put on our compassionate hats here. So he's alleging... We don't know what he's alleging. Federal question jurisdiction. Environmental matters, abandonment, and others, and identity theft. The reason why I'm not reading these words is because YouTube doesn't like words like that. And he says he was kidnapped in 1974, Colorado, and have been partying, boozing, and partying with celebrities and dealers and police officers. And I couldn't have a life if I didn't know the truth about who I really and honestly are. And he says Patty, who I'm assuming is his mother, removed him from the state of Colorado, and your city and community think that I'm this person of color, born and raised from and in the streets of Akron, Ohio, but I'm not. I was born in Colorado and I was brought to Ohio when I was 2, taken back to Colorado till I was 4, then brought back to Ohio in Akron. Identity theft states a baby might not ever see the truth until they're in their 40s. Okay. Patty was going to something my not person of color incubator, glass window in my face with her that, so that I was as nice as possible and made her think I was the child something she had in the second incubator. So switched at birth, I think, is probably the allegation here. I was in the 4th one. So I turned myself from... Okay, so he changed the color of his skin is going to be the best way that I can interpret that in a YouTube-friendly way. Relief requested that my name and social security number be changed from Yates to Bennett, and my birth certificate to say and have the seal of the state of Colorado, and for my social security number to be changed, as well as my race. Okay, let's see what the court is going to do about this one. So he's filed a civil complaint, pro se informa pauperis, against 2 individuals, Patricia Ann Averetti Yates, a resident of Dayton, and Sandra Bennett Robinson, a resident of Colorado Springs. Although the complaint is unclear, in it plaintiff states that Patty kidnapped him from Colorado, that he is not the person that he is, born and raised in the streets of Akron, Ohio, and as the city and the community think. Instead, he asserts that his birth mother kidnapped him and has been partying, etc., and that he couldn't have a life. Asserting federal question jurisdiction on the basis of environmental matters, abandonment and kidnapping and identity theft, and this one here, the relief plaintiff seeks is that his name and social security number be changed, etc., as we just saw. We've already gone over the standard of review, so I'm going to skip that. Upon review, the court finds that plaintiff's complaint must be dismissed. The complaint does not set forth allegations demonstrating the elements of a civil cause of action under any federal statute. So, no civil cause of action under any federal statute. And it does not identify a federal civil cause of action upon which this court may be granted relief. A court is not required to accept summary allegations or unwarranted legal conclusions in determining whether a complaint states a claim for relief. Indeed, kidnapping, the central premise of plaintiff's complaint, is a federal crime, and criminal actions in the federal courts are initiated by United States attorneys, not private parties. Accordingly, to the extent that plaintiff is alleging that defendants have engaged in criminal conduct, he has no plausible federal claim. Plaintiff has also failed to set forth any factual allegations that would establish civil rights under 42 U.S.C. 1983, which is the civil rights statute. So this case is also dismissed. So I feel a little bit bad. The person is obviously confused about their identity, or maybe there was some kind of switched at birth federal crime, but this was not the way to go about asserting it. And then there's one more of these things. So let's take a look. There is a complaint here before Judge Adams and Burke again, demanding a jury trial against the United States Patent and Trademark Office. I can do a better job there. There we go.
I'm just impressed at the diversity of defendants at this point.
This one claims diversity of citizenship. And it says, this is a new construction mute that needs time, patient, and attendance to be able to see the fairness amount the U.S. Secret Service and the USPTO owes Samuel Darnell Yates $50 million US. And he says, in the 3rd grade, I was approached by the U.S. Secret Service while I was preparing my exhibit for the school's science fair project. Well, when the officer approached me, I introduced myself and my project, but he took me away privately and we discussed the future happiness unto each other. You know, he likes to use unto each other, with respects of agreeing to let Mr. Yates redesign this country for the better. I ask the courts respectively to grant this motion to proceed unto the District of Columbia so that I can construct the releasing of trouble from this country and world. Electrical power line deaths are continuing to happen, plus the terrorism of stuff which can be stopped within the blink of an eye. So he thinks he can stop all the bad things within the blink of an eye. And that's apparently his complaint. So, not trying to bury the lead here, what do you think happened with this one? Well, Judge Adams has issued an opinion. Plaintiff alleges that when he was in the 3rd grade, he was approached by the U.S. Secret Service as he was preparing an exhibit for the school's science fair. Okay. Yates claims that he and the officer spoke privately about the future of happiness and plaintiff redesigning the country for the better. This constitutes the entirety of plaintiff's claim. In addition to seeking $50 million, plaintiff asked this court to allow him to proceed in the District of Columbia so that he can construct the releasing of trouble from this country and the world, which can be accomplished within the blink of an eye. Pro se pleadings are liberally construed. Nevertheless, the courts are expressly required to screen all in forma pauperis actions. Now I don't know if we've seen this statute before in this case, but we know from other in forma pauperis, like Edward Thomas Kennedy litigation, that 28 U.S.C. 1915 2b allows, once a in forma pauperis action has been granted in forma pauperis status, then the court has a duty to dismiss the action if it is frivolous or malicious, if it fails to state a claim, or if it seeks monetary relief from a defendant who is immune. So we'll skip past the standards for dismissal. The complaint must set forth sufficient factual matter accepted as true to state a plausible claim for relief. Plaintiff's claim is difficult to discern. The court is not required to conjure claims on plaintiff's behalf. Courts are not required to expend their time when the nature of a pro se plaintiff's claim defies comprehension. Even with the benefit of liberal construction, the court is unable to identify or direct or infer allegations in the complaint sufficient to support a plausible claim. Accordingly, the action is dismissed. Plaintiff is not a stranger to the Northern District of Ohio, as I think we've seen today. Between July and October, plaintiff filed 5 pro se lawsuits, including this action. I don't know that we didn't find the 5th one. So this is Yates v. City of Barberton. We saw that. Yates v. Yates, Yates v. Trump, Yates v. Yates in another case, I guess. And this one, the one that we're reading. In all these actions, plaintiff sought and was granted in forma pauperis status. All were dismissed according to 1915E that we just looked at. Up to this point, the courts in this district have been tolerant of plaintiffs' pro se filings adjudicated at the expense of the taxpayer, but proceeding in forma pauperis is a privilege, not a right. Pro se plaintiffs have no right to abuse the judicial process by repeatedly filing meritless cases. One acting pro se has no license to harass others, clog judicial machinery with meritless litigation, and abuse already overloaded court dockets. This court has a responsibility to ensure that the judiciary's resources are allocated in a manner that advances the interests of justice and the inherent power to impose appropriate sanctions, including restrictions on future access to the judicial system, to deter future frivolous, harassing, or duplicative lawsuits. This inherent power includes the power to revoke or deny the privilege of proceeding as a pauper when the litigant abuses the privilege by repeatedly filing frivolous and meritless lawsuits. Plaintiffs' repeated filings of meritless lawsuits in the Northern District of Ohio is incompatible with the privilege, and this court concludes that allowing plaintiff to continue to file cases in the Northern District of Ohio as a pauper does not promote the use of court resources in the interest of justice. Accordingly, in the future, Samuel Darnell Yates will no longer be permitted to proceed with civil litigation without payment of the full filing fee, at least in the Northern District of Ohio. For the foregoing reasons, the in forma pauperis application is granted, and he must pay the full filing fee if he decides to file again. And so this action is dismissed. Appeal could not be taken in good faith. It is so ordered February 11th. Thank you, Andrew Stoll, for the $5. Can I write up a movie script of this case and not get sued for $50 million by this? You could probably write up some kind of movie script on this. That's not legal advice as to what you would have to do to avoid, misuse of likeness or anything. But there's definitely a way to do it. So these kinds of things happen fairly often. And yeah, he wasn't paying the court's filing fees. So what would happen if he did? If he paid the court's filing fee, well, then he can't get dismissed under the 1915 standard that we saw. He can't get dismissed as a frivolous filing litigant under the in forma pauperis rule. So if he pays the $400 filing fee, the court has to do its best to treat his filings with that heightened pro se litigant standard, or rather, I guess it's lowered standard for a pro se litigant, where the court will have to do their best to construe the allegations in the best way possible for the pro se litigant. So yeah, that was the end of his Informa Pauperis filings, starting in July of 2019 and ending in February of 2020. So I feel compassionate for this person, because they are obviously of some diminished capacity in some way, and I really don't mean to make fun of them so much as this was definitely in some way entertaining, that there are really filings out there like this, and judges have to deal with them and then shut them down. And I can only imagine, from a non-professional opinion, just a personal guess, is that this person probably needs to seek some kind of help. And hopefully there are people out there who are doing their best to take care of him, and that this is just something that has happened because people have access to the court system and Informa Pauperis status.
So Big Dero says that they're shocked at the waste of the court's time in responding to this. Did you want to talk about why the court is taking the time to cite the case law and to be really thorough when they shut it down?
Well, you have a due process right to have a fair and impartial, meaningful proceeding, and meaningful proceeding usually means some kind of reasoned opinion. So just a court saying denied, it is so ordered, is not necessarily a meaningful proceeding under the Fifth Amendment due process, either what we call procedural due process or substantive due process. So the court has to at least give a meaningful opinion. And even though the court could probably get away with shutting down an Informa Pauperis litigant, and you know how many people are going to appeal, well, it's a lot easier for the judge to give the reasoned opinion, and then the appeals court has more to go off of. So the judge summarizes the law, summarizes what they think the plaintiff, in this case, what they think the plaintiff is alleging, and then shows how they're shutting them down. I'm not saying that it's not an easier time for a judge to shut down a frivolous or a lawsuit that doesn't reach the standards for a short, plain statement of the facts and the entitlement to relief. But it's something that the court won't have to spend too much time on. But yeah, you could imagine being a judge, getting these kinds of things, and then you have to spend your time and effort responding to them, even when it's obvious to the vast majority of people, and definitely to every legal professional out there, that these are either frivolous, or vexatious, or just inadequate filings. Also, let's say thanks to John Gingras for the $10. Just got here. He says, looks like I missed an interesting one. Hopefully everyone's having a great day. You know what, John? I am having a great day. I started out last night not feeling very well at all, and I'm feeling well enough to do a live stream. So that's a vast improvement for me. And thank you for your thoughts and comments. Does anyone have any final thoughts or comments or super chats? Super chats are always welcome before we close out this stream.
I kind of think the last lawsuit was probably the best one to end on, because really he wants to be given the go-ahead to make happiness in the world, and there's something really sweet about that.
There is.
I'm not sure about the $50 million, but really at the heart of it, he's like, I know how to make the world a better place. Just let me. And my heart goes out to that.
And you know, it sort of touched, in the non-weird sense, the third grader in me, who, wanted to help the world. I still want to help the world, but I'm now more effective at it. Our YouTube channel and the things that I do are more effective than hoping that some U.S. Secret Service will contact me and be like, "You're the one, Neo. You get chosen to save the world." That's actually not a thing that happens. But But yeah, when I was in third grade, I definitely thought it would be cool for that to happen. I think that I've definitely matured out of those thoughts, and so I feel compassion for a person who thinks that was actually going to happen. Also, I have my serious doubts that anyone actually told him that in the third grade. I think that might be a false memory. That might have been a dream that someone had, or a thought that maybe became too pervasive. So yeah, I hope someone's helping him. So yeah, thank you for joining me. I'm Leonard French, your favorite copyright attorney. That is our show. This will be on the channel as a video on demand, or DVR, or whatever YouTube calls them these days. This is a community-supported legal education channel. Thank you for your financial support on patreon.com/ljfrench and sponsors.com/law. We would not exist without your financial support, as the instability of YouTube doesn't allow us to, always make the amount of money we need to cover our expenses and time and effort and all that. So we really appreciate the following $50 plus supporters in the month of February: Aspernari, Video Demonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen, Cute Grills in Your Area, Ottah, Kysal, and Longreach Jones. Really appreciate you all. And the $5 plus supporters and the $50 plus supporters will all be in the description of the video. I love you all. Thank you for coming. I'm Leonard French, and I'll see you in the next one.